Do you know what happens to your assets if you don't have a will? What about a power of attorney? If the answer is no, that's okay, you're not alone. Getting your estate plan in order doesn't have to be stressful or complicated. We are here to help you. Not having the proper legal representation while you're getting an estate plan in place can land you in more trouble than you think. I'm Jennifer Nichols, the owner of J. Nichols Law. Today, I will outline 6 essential elements needed in your estate plan. These will help protect you and your assets and guarantee that your estate is distributed according to your wishes. Most people don't realize that a will isn't the only thing you need to get an estate plan started, but it is a crucial step here in Texas. So let's start with the basics. What is a will? A will is a legal document that states what happens to your assets after you pass away. In it, you name an executor, the person responsible for carrying out your wishes. You can also designate a guardian for your minor children and even set up trusts to manage assets for your loved ones. But here's the key. Just having a will isn't enough. It must be appropriately drafted and legally valid to hold up in court. Having a will properly drafted is critical, but what happens if you don't get one done? Without a will, Texas law decides what happens to your estate, and that might not align with what you want. A will gives you control over who inherits your property and how it is managed. It also helps avoid unnecessary family disputes and legal complications down the road. And when probate is necessary, having a will expedites the probate process and reduces costs. A will can also minimize estate taxes by structuring bequests in a tax-efficient manner. Another important part of an estate plan is a medical power of attorney. A medical power of attorney allows you to name somebody you trust to make medical decisions for when you are incapacitated and no longer able to do so yourself. These decisions include choosing doctors, consenting to medical treatment, and deciding on surgical procedures. Another type of power of attorney is the statutory durable power of attorney. A statutory durable power of attorney allows a trusted person to make financial decisions on your behalf. An agent under a statutory durable power of attorney can take actions in connection with your bank accounts, investments, and real estate, among other things. You can also add special instructions to the statutory durable power of attorney to add additional powers or to restrict certain powers. Importantly, powers of attorney must be in place before you need them. Waiting until it's too late can lead to a court stepping in to appoint a guardian to make financial and medical decisions for you. Speaking of guardianship, if you have children under 18, having a declaration of guardian in place allows you to select somebody to be able to take care of your children when you are no longer able to do so. When you are deciding this, you may want to think of the family members that know your child best or a close family friend. In a declaration of guardianship, you can even designate a guardian for yourself in the event a court should decide you need a guardian later on. While having powers of attorney in place typically prevents the need for a guardianship, there are cases when having a guardianship is still necessary. For example, if you become incapacitated and a target of exploitation, your agent under a power of attorney could not prevent you from being exploited, but a court-appointed guardian could. Another important part of an estate plan is a directive to physicians and family surrogates, also known as the living will. This document allows you to communicate your wishes regarding use of equipment to keep your body alive, such as breathing machines. It comes into play if you have a terminal condition and aren't expected to live for the next 6 months, such as stage 4 cancer, or have an irreversible condition and can't take care of yourself, such as brain damage. Now, let's talk about trusts. Trusts allow you to leave assets to loved ones without giving them direct access or control. A trustee manages the assets for you and makes sure that they are used responsibly. You can structure trusts in your will, called testamentary trusts, or have a standalone trust outside of the will called an inter vivos trust. There are many different types of testamentary trusts and inter vivos trusts, including retirement benefits trusts, living trusts, special needs trusts, and more. Structuring these trusts correctly is critical, and that's where expert legal guidance comes in. Estate planning can feel overwhelming, but you don't have to figure it out alone. At J. Nichols Law, we take the time to understand your unique situation and craft a plan to meet your needs. Call us today if you are ready to protect your legacy and your loved ones. Let's ensure your wishes are honored and your legacy is secured. Thanks for watching. If you like this video, please like and subscribe and turn on your notifications for more videos like this. See you in the next one.